My lord, mention on return or motion.
The 18th June is the date, last date fixed.
Write your date, give it, it will appear.
My lord, application of a contest application.
Extension of file without certified copy.
By when was the order passed?
Not the order is dated actually 16th of April 2026, but not the order gets uploaded by NCLT not almost 1.5 months late. That is why.
My lord, release matter applied for certified copy.
We have applied for that.
My lord, few moment, my lord. Argument already fixed, partly hard already, my lord, line civil court. Kindly fix any date next week, my lord, and I'll become infractious.
Write your ground.
My lord, already.
My lord, one matter.
Extension of entry.
Well, I am mentioning item number 20 of this list, my lord. This revision should be allowed, directed to be appear along with CO number 700 of 2026.
Oh.
That is item number 1955. Let this be also be added along with.
দুটো একসঙ্গে দিয়ে দেবেন তাহলে
Your Lordship, Your Lordship,
if it is called today, you remind me, we'll.
Yes, yes. Because if it is not called today, যেটা আজকে number 20 আছে এর সঙ্গে এইটা যাবে
পরের দিন দুটো একসঙ্গে আজকে নট টুডে করে দিন, পরের দিন দুটো একসঙ্গে দিয়ে
You'll-
দিন, ওটা
you-
বেটার মিস্টার I'll not call this today then.
Your Lordship, Your Lordship, may I have Your Lordship kind leave to mention one matter, that is serial number 86, Your Honor, for upgradation of that.
Write your grounds of urgency, give it, I'll upgrade it.
I'm grateful, Your Lordship.
Lordship, may Your Lordship, may I be permitted to mention a matter?
Write your grounds of urgency and give it. Why do you need to mention?
Your
Please call
Lordship,
the-
Your Lordship,
call করুন, ছেড়ে দিন।
Lordship, this is a restoration application, Lordship.
on 15 December,
Lordship, this is a
I
restoration.
said, write your grounds of urgency and give it.
Your Lordship, we have been writing it from the month of January. It has been month of June. The entire suit has been stayed.
Can't be helped. You are appearing for the opposite party.
No, we are for the petitioner.
Then you have obtained the order of stay.
But Lordship, the matter has not been.
So it will not be listed.
My lord, this is a restoration application.
Restoration.
Yes.
Now, my lord, initially, my lord, item number 26. Now, my lord, going down, my lord, 47.
Because of the upgraded motions.
Updated, my lord, kindly, my lord.
So please write your grounds.
Yes, yes. I've already, my lord. 47.
With my lords, kindly may I be
চলুন list call করুন দিন।
with my lords, kindly may I be permitted to mention this matter.
Please write your grounds and give it, sir. Why do you need to know? I will not entertain oral mentioning it. Unless
It's on month of July.
I will not extend or I will not entertain oral mentioning. Please write your grounds, give it. Next, চলুন দিদি call করুন। Every day same thing.
Your Lordship, I am appearing on behalf of the petitioner.
It is wrong. Date.
Mistake.
If only one indulgence.
Write it and give it. This. Same mistake, date 2026. It should be, it has become 2025. Same জিনিস. Same order. Next. Three same order.
I'm for the petitioner.
ওই সেম অর্ডার, সেম ডেট, সেম অর্ডার, সব একই ভদ্রলোক টাইপ করেছেন, সব একই ভুল করেছেন। সেম অর্ডার। নেক্সট।
The sixth, my lord, I appear for the opposite party. My lord, this matter was mentioned at the instance of the petitioner. My lord, kindly now, my lord, have a look at the impugned order. My lord, this is a case of maintenance under section 24 of the Hindu Marriage Act. My lord, order was passed in our favor, in favor of the wife on 3rd of April 2025. Challenging that, my lord, they preferred the revisional application. My lord, when the revisional application was taken up,
This was mentioned, this was upgraded on your mentioning.
No, on their mentioning. I am suffering. I had suffered an interim order. They chose not to file any extension. While the interim order was subsisting, I had filed a vacating application. Now
Interim order is not there anymore.
no interim order is not there anymore, but there is no clarification because they have filed an extension application. They are taking dates before the trial court, and the order of maintenance is unexecutable. That is my difficulty. Admittedly, the husband is earning 34,500, which he has admitted in his affidavit. Now he wanted to show that I am earning 13,500, which is a false fact. I have given that fact in my vacating application, showing that I am earning today 2,500 only. Now they are taking, my lord, the advantage of the keeping this application pending.
For this petitioner, your lordship, playing for short passover, seizing my senior, who is appeal, who will appeal
Last
for
same thing,
petitioner is engaged.
Passover, my lord.
Short of passover, your lordship.
Lord, kindly appreciates my condition, my lord. I am not.
Well, what is the condition? There is no stay. What,
But my lord,
what
the
will I
trial court
appreciate?
is not proceeding.
Trial court, you impress upon the trial court
No,
because
that
the
is
trial
the
court is
difficulty,
not
your lordship
understanding.
knows.
You need a
They are
clarification.
saying that.
Please stop. Necessary.
Grateful, your lordship.
It's a case of maintenance, my lord.
So very well, I'll hear it tomorrow. He's asking for a Passover. You want me to wait for you?
Last
What
day
kind
also,
of attitude
no,
is this?
last day also they sought for a Passover.
This is the first time this is taken up by me.
No. Prior to this, your lordship had taken up this matter once.
I don't remember. There is no endorsement. Passover কি তো আপগ্রেডেড করিয়েছে তো, কোথায় স্লিপটা কোথায় লিখে নিন। None appears for the petitioner. Full stop. The opposite party is represented. Full stop. Not today. Not today. Go out কেটে দিন। Passover চেয়েছে।
Your lordship, then kindly take it up next week, Monday, tomorrow, I may not be available.
লিখে নিন।
Lordship, kindly.
An adjournment is sought for by the now on behalf of the petitioner. Let this matter appear next week.
I'm appearing on behalf of the petitioner. Short pass.
Next week.
My lord, better to appear in item number 6. Your lordship, better to appear next week.
Next week. Yes.
My lord, in item number 6.
You prayed for time. I have made it not today.
My lord, there is an urgency actually.
Then why were you not here, madam? Yours was the first
I
matter.
was in leave, my lord. I stuck in leave, my lord.
I've made it not today. The other side was there. He has left. Next.
If I call other side, my lord, can you?
I don't know. Try to be here. When you get
My
the
lord, I
matters
can
upgraded,
understand.
don't do this. You all waste time for 10 minutes in the morning every day while mentioning. When matters are upgraded, nobody is there. Neither you were there. In the next matter also, there is nobody there. Why should I upgrade then?
My lord. Well, I can ask.
Next call. Kuru.
Only there is a matter fixed.
I don't know, madam. You were not there. He was there. I have made it not today. You bring him. We shall see. Next.
Loss, item 7, loss.
Not today. Yes. Next.
My lord, kindly give a short passover. Mr. Amitabh, who is leading in this matter, has got stuck in the jam, my lord. Kindly give a short passover, my lord.
Kind of. Why do you upgrade matters? Likhen in act order. I'm going to be very harsh now. Every day you mention.
Apologize, my
matters,
lord.
I
Kindly
upgrade
give a short
matters.
passover.
No. An adjournment is prayed for on.
Has come pursuant to your lordship's order as an that this kindly takes up the impugned order. There is already a stay that I am enjoying. The honorable court was annoyed since, my lord, the learned advocate didn't go to move the application seeking for adjournment. That is why, my lord, by the impugned order, the plaintiff's, my lord, opportunity to cross-examine the learned advocate commissioner was closed.
How many times before this, Mr. Lahiri, adjournment was prayed for cross-examination?
It's not much. My lord, I have annexed the entire order sheet. Kindly comes to the previous, my lord. I think once it was paid, kindly comes to from page 32 onwards.
Yes.
33 onwards, I think. It was adjourned. Thereafter, this was adjourned because of the regular PO was transferred. And thereafter, my lord, 34, defendant final application for fixing an early date for hearing the acceptance of the filing, accepting the final commission report. Date was fixed. 35, my lord, regular PO is transferred, fixed on 29th January 2024 for acceptance of the commissioner's report. All concerned parties are directed to present personally. Thereafter, my lord, this record is taken up, page 36, it is taken up for plaintiff's advocate commissioner is cross-examined by the learned advocate for plaintiff in part. Cross-examination is deferred on the prayer of the plaintiff. Here the cross-examination commenced and it was deferred. Thereafter, my lord, again it was deferred for further cross-examination. Page 38, regular PO is transferred and the case is adjourned today. Thereafter, my lord, an application was made that the learned advocate was engaged in, my lord, Shialda court. He couldn't go. Kindly comes to, and my lord, the medical report was also annexed that the plaintiff was sick and my lord could not attend. The medical report was also annexed. My lord, this application was not moved. That is the grievance. Kindly comes to, my lord, the order at page 32.
What is the stage of the suit now?
At the stage of, my lord, preliminary decree has been passed. My lord, this is at the stage of, my lord, penultimate stage.
The partition suit.
Yes, partition suit.
Madam, if
Only
one
one-
day for cross-examination.
My lord, kindly allow me for that. This is a partition suit. Preliminary decree was passed in the year 2015. Thereafter, amicable partition was not done. On the behest of the defendant, partition commissioner was appointed. He has submitted his report in the year 2023. Thereafter, several times they have cross-examined. In the meantime, at the time of passing the preliminary decree, there was an order that both the parties should maintain status quo with regard to the nature, character, and possession of the property. Thereafter, on 10th September 2024, they have again filed an application for injunction. During the
But that is not the subject matter.
that has taken the state application was disposed of in the year 2025 on 17th July 2025. Thereafter, they have taken 2 or 3 times for adjournment and
No, we have
one day. I will fix one day. On that day, they will have to conclude. And for that, you should.
that was the indication in the order. Kindly seize the order passed by the Honorable Justice Shampa Sarkar on the first date. Order dated 2nd January.
Order dated
2nd January 2026. Petitioner filed an application for such and such, praying for recalling of the order as none appeared on behalf of the petitioner on such and such. The cross-examination of the learned partition commissioner was closed. According to the learned court, the petitioner was delaying the partition suit for
I'll about costs also, as I said at the beginning, because I always do in such matters.
yes. Cost vehemently opposed to the last. Kindly record that. But there will
No,
be
that will be court's order. Because if we have prayed for 2 adjournments.
no, we have
The first into his lordship's direction, I have served, my lord, as delivered, my lord. A testamentary suit, my lord. I have appeared for the executive have filed application for grant of probate, my lord. On the, if my lord kindly sees the impugned order dated 28th of November, my lord, wherein, my lord, I have started the cross-examination of PW1. On that day itself, my lord, I could not complete. I have started. I have prayed for an adjournment on the ground of the learned senior counsel who are 28th November. On that day itself, my lord, I have started, my lord. I have also obtained the certified copy of the cross-examination. 8 to 11. No, for my kindly sees society also files Hazira. Today is fixed for cross-examination PW1. Accordingly, PW1 Shankar Das Kumar Das is further cross-examined with learned advocate for the society and discharged. Further for PW is PW2. It is PW1 executor. PW2 is a attesting witness. So PW1, I wanted to kindly see. I have also filed application, my lord. I prayed for adjournment. Only one date required. The learned court below closed the evidence. No, I have made an application for. Yes, I started cross-examination. I could not complete. I filed an application that I have filed a certified copy of that adjournment application also for deferring the date. The court below, my lord, closed the cross-examination of PW1. No, on the initially at the time of cross-examination, only I have prayed. This is the certified copy. Yes, it was concluded. But kindly sees the application itself. I have given the certified copy also, my lord. Yes, instead of deferring, it has closed, my lord. I wanted only one date for further cross-examination only. It was initially on the 8th, my lord, pursuant to the lordship's order that has been adjourned. In the July, it has been fixed, my lord. I have served, my lord. They have. Let it be under here upgraded motion.
আচ্ছা, আমি বলছিলাম না স্যার যে আমি ওই ওয়াকআপ টাইম উইনার থেকে 3 বছর থেকে না, আমি 2023 থেকে মানে আমি কেস করছি উকিল বাবুকে দিয়ে। তো 3 বছর থেকে না গিয়ে লাস্টে একটা অর্ডার হলো, বাজে একটা অর্ডার দিয়েছে যে আপনি কোনো ডকুমেন্ট ফেলেনি। তো আমার হেতা ডকুমেন্ট সব রেকর্ড, খাজনা, ট্যাক্স, ডিড সব দেয়া আছে স্যার। আচ্ছা স্যার, আচ্ছা স্যার আমার কি করলে কি হবে স্যার, একটু করে দিন।
ওই বিল্ডিং এ আছে, পাশের বিল্ডিং এ লিগাল এড আছে, ওখানে জজ সাহেব বলছেন।
ভালো অর্ডার করে স্যার, একটা ভালো অর্ডার করে দিন স্যার।
Opposite party, I am praying for passover, my lord.
This is a affidavit of service. There's a caveat. I have served. My date is fixed on the Monday. If it's passed over and called on, my lord, I have no issues. Short passover. But no, my lord, the date fixed before the trial court is on Monday, my lord. Let it retain its position.
We'll start. I'm opposing. Lord, this matter led by Mr. Jitendra Banerjee, my lord. This matter was heard by your lordship. He is in court number 90. I'll just start the matter. I think he will join. Then we'll let this. So addressing your lordship actually, Mr. Banerjee. Well, under the same heading.
I am for the opposite party, my lord. Shiva Prasad Ghosh is the conducting advocate. Her elder brother is died tomorrow. He has come to it today, 2 p.m. Please kindly pass over. 2 p.m.
Lordship, item number 50.
Sixteen, Lord, I appear for the petitioner seeking expeditious disposal. Only, Lord, two short facts. Money suit filed in 2023, Lord. Defendant didn't file the written statement. After a lot of persuasion, filed. Very next day, files an order 7 rule 10. I file my objection. That was in September 2023. Lord, till date, Lord, the application has not been taken up, despite repeated Lord put-ups filed by us. To be disposed of. Your Lordship, may kindly just, my Lord, for my Lord's kind information, kindly turns to paragraph 12 once, my Lord, just for once. Very well. My Lord, some limited timeline, my Lord, because for 2023 we are moving. My lord, before that court, my lord, Alipur court. Oh, when? Your lordship, it was filed on 18 September 2023. That's mentioned in paragraph 12.
My lord, appears for the opposite party.
My lord, he's on his legs now. I'm praying for a Passover.
My lord, I am praying for my lord 2 weeks time, my lord, because he has been suffering from my lord pain in waist, my lord. He cannot do. Yeah, because interim order is there, my lord.
My lord, I am not briefed in this matter, so I'm
My lord,
praying
he
for
has,
Passover.
he has been enjoying the stay order, my lord. My lord, only 2 weeks time, my lord, because recovering. Interim order is there, my lord, till June, my lord.
That may be extended.
Opposite party, the defendant Miller suddenly come up with an application under Order 14, Rule 2 of the CPC Miller. The issues were not framed, Miller. Without the issues being framed, Miller, Order 14, Rule 2 application was taken up for hearing, Miller. And Miller, by passing an unreasoned order, Miller, we kindly seize the order dated 7/11/2025, Miller. No reasons were given, Miller, but a preliminary issue was. No, Miller, may kindly seize the application, their application, Miller. But I am aggrieved. Miller, why I will tell you lots, Miller. Court so much offense, but Milord, he has the other side has sought for that since there is an ROR, Milord. The issue has been framed because there is an ROR. No, Milord, there is an ROR. Issue has been framed on an ROR, Milord. They say because my name is not in the ROR, hence I am not. No, Milord, may kindly, my lord, may kindly fix a day, fix a time period for hearing of that. Because Milord,
I am for the petition.
I am for the opposite party.
It's a 218 proceeding under the West Bengal Municipal Act. The Lordship knows, my lord, against that, my lord, under 218(3), the regular, my lord, appeal before the civil judge. So where, my lord, initially, my lord, a writ. My lord, temporary. My lord,
There was a proposal for a constitution of a tribunal against that also at one point of time.
no, my lord, in 218(3), the word is for civil judge itself.
No,
That-
there was a proposal for amendment.
Oh,
because
that-
or maybe since the judge was not available, therefore writ petition, something had happened.
No, till date, my lord, that's the civil judge. So, my lord, here the initiation of proceeding was by way of a writ petition alleging unauthorized construction on my part, where I was a private respondent. If your lordship takes up, my lord, page 13 of the, my lord, civil divisional application, that's the first order passed by this honorable court, my lord, coordinate bench, my lord, directing the Contai municipality to submit a report in response to the allegation made in the writ petition within a period of 2 weeks. My lord, page 13 of my lord's.
1-3.
1-3, my lord. WPA 25526.
Yes.
Directing the Contai municipality to submit a report. If your lordship takes up, my lord, the report, page 15 of my lord's brief, it starts. I will only place one paragraph which is important. German. Paragraph number 5 at page 16 of my lord's brief. That in perusal of the aforesaid report, it appears that there was 450 millimeter. My lord, it's equivalent to 17 inches. .450 millimeter open space found at ground floor in between both the building constructed by the petitioner and the private respondent, but Suparna Maiti has extended slab over ground floor, first floor and second floor up to 450 millimeter. As such, there is no open space in between both the two buildings. So, my lord, ultimately it is found that there is a projection to the level of, my lord, 17 inches in each floor of a slab. That was, my lord, the finding of the, my lord, report submitted by the Contai municipality. May I take your lordship, my lord, thereafter, my lord, page 17 of my lord's brief, the writ petition was pending, the orders was passed, paragraph 2 at page 17, the coordinate bench, when the matter again came up. May I place paragraph 2? Learned counsel for the respondent states that after inspection, it is found that 450 millimeter open space found at ground floor in between both buildings constructed by the petitioner and the private respondent, but Suparna Maiti has extended slab over ground floor, first floor and second floor up to 450 millimeter, and as such, there is no open space in between both the buildings. That is, my lord, the finding. Now, my lord, kindly turns over. The action taken report is directed to be filed at paragraph 4, my lord, page 18 of my lord's brief by the coordinate bench. Since, my lord, there was a illegal construction found up to, my lord, 17 inches in each floor. Lord, if your lordship takes up now, my lord, page 19, because the matter was made pending. My lord, page 19, this is the order dated 11th of November 2025. My lord, the court recorded that the report was directed to be filed in view, paragraph number 3, in view of the aforesaid, I direct Chairman Contai Municipality to file an affidavit before this court explaining circumstances under which such report has not been filed, since the report has not come. Now, my lord, kindly takes up paragraph 20, my lord, page 20. The next date when the matter appeared, no report was filed. Since the conduct of the chairman was so that the court order is not being, my lord, adhered to, my lord, this honorable court coordinate bench directed ultimately the personal appearance of the chairman. But I am not disturbing regarding the entirety, my lord. While doing so, my lord, at page 22, the coordinate bench recorded that what is the extent of violation and directed the chairman's, my lord, personal appearance. Now, my lord, kindly takes up, my lord, page 23 on a hot haste when, my lord, the chairman's personal appearance is being, my lord, asked for by this honorable court. Immediately a 218 proceeding was initiated, my lord, by the Contai municipality, and by the, my lord, your lordship will get the order, my lord, it's 28th of November 2025. The previous order of personal appearance was of, my lord, 25th of November. And this order is being filed, my lord, is passed on 28th November. It's not that, my lord, I was not heard. My lord, I must be clear before your lordship. My lord, page 24, my lord has seen the date of the order. It's an order passed under section 218. Page 24, my lord. So just 3 days thereafter. My lord, may I take your lordship to the relevant portion? Your lordship need not go into the. My lord, kindly takes up page 28 once. I will read only paragraph number 2. As my lord, I'm sorry. My lord, page 28, paragraph number 2. It's the observation by Board of Councillor. Both the reports further suggest that there is no building plan of the opposite party and there is open space only 450 millimeter in between the buildings. So, my lord, now they are of the view that I as if do not have any building plan of the petitioner and the opposite party. Both the reports also suggest that the opposite party extended slab over first floor, ground floor, first floor and the second floor up to 450 millimeter. There is no open space in between the ground and the 2 floors. Now, my lord, ultimately by virtue of this, the page 29, they directed the entire construction held to be, my lord, that unauthorized. Since I am having no sanction plan, apart from that, my lord, there is a deviation of 17 inches. When, my lord, this order is being passed on 28th of November, kindly, my lord, turns over the page, because on the day, I must be, my lord, clear before your lordship, on the day when the hearing was take place, my lord, on 28th, my lord, it's the order passed. Prior to that, my lord, the hearing took place. Kindly takes up page 31. Since on the day of hearing, I was not having, or rather not carrying the original sanction plan, I was directed, and 29th of October, your lordship kindly takes up page 31, 29th of October 2025, I submitted my original building plan, which is part of the revisional application also before your lordship. So I submitted that. Maybe on the day of hearing, I could not able to satisfy, but thereafter, prior to the order which is being passed, this original sanction plan is being supplied to them. Kindly takes up, page, next page is the sanction plan I have annexed. Now, since this order is being passed, ultimately, page 33, that writ petition was disposed of. Since a final order has now been passed, though my junior was not there to ask for an interim protection, but the learned judge is of the view correctly, that there is a statutory forum available. So you go and apply that. But thereafter, I preferred the appeal, under 218(3). And also prayed for an interim order before the learned trial judge. Kindly takes up now, the impugned order before your lordship.
Yes.
May I take your lordship, my lord, to the only the second page of the order impugned, clause number 10, because that's the consideration part. The facts I have already narrated before you. On plain reading, my lord, has your lordship got it? On plain reading of the document submitted by the parties, it appears that the Board of Councillor initiated this proceeding under 218 of the Act in compliance of the order of the Honorable High Court at Calcutta. It further appears that the impugned order of the Board of Councillor, Contai Municipality, that this appellant was appropriately represented and also participated in the hearing before the board. It further appears that the Board of Councillor arrived at a decision that the construction in question is illegal and beyond sanction plan, and accordingly proceeded to hold that the same needs to be demolished. Next, upon perusal of all materials before me, it cannot be prima facie held that the proceeding adopted by the Board of Councillor of the Contai Municipality is violative of the principle of natural justice, and the same originated out of a proceeding behind the back of some of the co-owners of the establishment and is suspicious or high-handed. Thus, considering the document available at this stage, this court is of the view that no order of stay is warranted. Lord, I am not placed the case about, Lord, that I was not heard. My case is that whatever I given, that was not considered properly. So today I am before a forum where 218 proceeding is under challenge, whatever the order is being passed. If I am not being able to protect my property till my appeal is being heard out, because today, my lord, I am before your lordship against my ad interim refusal. So today, if a prima facie case,
does this order show that the plan was not there before the Board of Councillors?
Yes, the order before the Board of Councillor, my lord.
Yes.
Yes, yes. Lord, may I place that portion again? Your lordship takes up the order, starts from page 24.
Yes.
The portion where it has been recorded, page 28, if your lordship takes up.
Yes.
Paragraph 2 and paragraph 4 deals with such situation. Paragraph 2, both the report further suggests that there is no building plan of the opposite party and there is open space of only 450 millimeter in between the building of the petitioner and the opposite party. Both the report also suggests that the opposite party extended slab over ground, first and second floor up to 450 millimeter, which is equivalent to 17 inches. There is no open space in between ground and the said two building. Now, point number 4, Milord, that subsequent report also highlighted the same thing, that the petitioner construction found unauthorized and in accordance with building plan. The opposite party could not produce his building plan. Hence, there is no option left but to declare construction of the building of the opposite party is unauthorized. That's why, Milord, I have shown before your Lordship, I must be candid on the day of hearing. I could not. That's why I have been directed to supply, and I have supplied long back. I have supplied the building plan on 29th of October.
Hearing, what was the direction? Where was the direction to supply?
No, Milord, that was a verbal direction. And Milord, today, the content.
When was the hearing taken?
Milord, the hearing was taken. Milord, may I just. Milord, kindly takes up page 24. It has been written here. In compliance of the said solemn order, the chairman issued a notice on 25th of October 2024. Has your Lordship got it? Fixing a date of spot inspection on 14th of November 2024, such and such. The said engineer conducted an inquiry. Mr. prepared a report. Board issued notice on 8th of September asking the parties to appear before the board for hearing. On 18th September, hearing took place, Milord, at 4 p.m. Milord, page 25 top. And Milord, Contai municipality is a party to this proceeding. Today, the authenticity, veracity or genuinity of the plan, that can also be verified. Milord, I am not shying away. But today, the thing remains whether...
No, my Lord, I have the short submission. I am not concerned with the sanction plan. Whatever the sanction plan, that will be verified by the court below. But I am concerned with the 450 millimeter. Because my read petition was that since there was an open space in between the building of the petitioner as well as the building of my client, the petitioner unauthorizedly constructed this 450 mm up to second floor. As a result of, there is no open space. And this portion is not being covered by the sanction plan. Therefore, my Lord.
But then sanction plan is required to be seen.
Sanction plan, let him show. Not a sanction plan, he has got the sanction plan. Let him show that this unauthorized construction of 450 mm is being covered by the sanction plan. They cannot show. Because this sanction, please, my Lord, 1993. They have constructed the building in 2025. This unauthorized portion 450 mm. So that cannot be covered by the sanction plan. Let it be demolished. So far the sanction plan is concerned, lower court below will adjudicate and will verify it. But so far the unauthorized 450 mm is concerned, let the municipality demolish it. But this is not being covered by the sanction plan. This is totally unauthorized one.
There are two aspects of unauthorized construction.
Here are two. One, building plan. He has obtained the building plan after hearing that. And that building plan is covered so far the building is concerned. So far the unauthorized construction regarding...
Mr. Mukherjee, what about this?
Yes, Milord, I know, Milord, that was the first submission made by Mr. Banerjee even on the first day when the matter was moved and obtained the interim order. Kindly consider, Milord, today it's my civil revisional application I have came up against refusal of my ad interim prayer because the order is one. Is under challenge before a statutory forum.
But
no, Milord, today
27 vote is a court of equity also.
Yes, Milord, I'm on.
Court of equity.
Today, I have a submission with regard to that also. Because now, Milord, Rule 50 of the West Bengal Building Rules 2007 is being amended with a power to the authority to regularize. Because today, the authority has not exercised that power. The Rule 50 is being...
That you will have to take steps.
That's why, Milord, today I am before a statutory forum wherein the entire component.
This order of refusal does not prevent you from taking steps to regularize if the authority.
That's where I am on. Milord, today he cannot ask for in my civil divisional application a demolition order from your Lordship.
No, I will not pass an order of demolition.
Yes.
But I will not interfere with this order also, leaving you free to apply for regularization.
If today the
demolition order had been passed by the municipality.
I am not
In
interfering
terms
with
of
that.
the order of the
If your
rector.
lordship, but if your lordship today, suppose the order of demolition of the municipality suggests entire demolition of the building, entire construction, kindly comes up, my lord, to the operating portion of the order. Page 29, if your lordship kindly takes up. Paragraph 3. As my learned senior friend is suggesting, there are two parts. The operating portion which has been, my lord, directed is this. The board, my lord, paragraph 3. May I place, my lord? The board further directed the opposite party that the unauthorized construction must be dismantled within 15 days, passing the order at his own expenses, causing damage to the neighbor, without causing to the damage to the neighbor, and such work of demolition must be must not cause environmental pollution, failing which the board of councillors had demolished. So entirety of the construction is being directed to be demolished. It's not that any phase wise
Your building will be protected. I am not questioning that.
Today, my learned friend wants to.
What is sanction plan? Your building will be protected. The learned court bureau will verify it. But so far the unauthorized is concerned, he cannot take that point.
So my learned friend is saying that I cannot protect so far as regards
that. My lord, there is no open space. I am not getting any air.
That's not attain finality.
This is the question.
That's not attain finality. The 218 court can very well. Well, the 218.
You arbitrarily, I lodge this complaint. You arbitrarily construct the entire up to second floor without giving an open
where
space.
both the facts and law are available. This is like a first appeal.
But that construction is to be demolished.
Lord, may I?
Because you have got no sanction plan to that extent.
The both facts and law are involved, in my appeal. The court is not denuded with the power that he can ask for an inspection also.
Mr. Mukherjee, the order has to be read as a whole.
Yes,
if you see page 28, paragraph 2.
Paragraph 2, yes.
There are 2 points which have been taken by the Municipal Building Tribunal, Board of Councillors. One is that there is no building plan. Therefore, the entirety of it is Dihorsa building plan. Second is that the open space is obstructed.
Yes.
So far as there is no building plan is concerned, that I can say that the court should pass an order of stay. But so far as this open space is concerned, that I can leave open.
Is it if it is like a watertight case that I don't have any avenue before a 218 statutory forum?
I will not stay this, but in that case, I will observe that you have liberty to take appropriate steps if you have in law for regularization.
Yes,
that I can say.
Yes,
but this will not. I will again clarify that this observation will not mean that you will be granted regularization. That will be
certainly not. Certainly not, because there are other factors. Yes. But so far as regards this order is concerned,
as regards this order is concerned, I'll clarify that so far as the demolition of entire building is concerned, that
remains state.
That will be state subject to, but the stay will not operate so far as the open space of 450 mm is concerned. The petitioner, I'll record your submission that you say that in accordance with.
I'm just handing over before your lordship.
You will be entitled to.
Yes, my lord. I'm completely. Bow down to your lordship's authority.
And you'll also kindly direct the misappeal court to dispose of the misappeal.
That I will do.
Right. There is a doubt in the plan also. That's why the court below will verify the plan.
Consider because Mr. Mukherjee, if you see,
my lord,
come to page 25.
Page 25, yes. My lord.
You are the opposite party here, no? Not the petitioner.
I'm the opposite party over there.
Very well. Then your plan, the building plan submitted by petitioner means Mr. Dotto's plan.
Yes. It is his building plan.
লিখুন উনি দেখাচ্ছেন ততক্ষণ this revision
434, Mr. Omole Roy appearing for the petitioner, Your Lordship. He is on legs, Lordship. I am praying only not today. Fine. So, yes, Lordship. He's then kindly, I'm praying for short passover. I contact you.
চলুন কল করুন নেক্সট।
My lord, I'm appearing on behalf of the opposite party. I'm being led by Mr. Dipendu Kundu. I'm praying for a short Passover, my lord.
দেখি দেখি
In this matter, I appear for the opposite party. 21. Well, this is my application, Your Lordship. Kindly sees, on the last occasion, Your Lordship directed me to serve. My lord, I have duly served. My lord, this is the affidavit of service. My lord, they are appearing as well. My lord, the matter pertains to, my lord, an order dated 27th of January 2026, wherein, my lord, an order was passed. My lord,
go a little further from the microphone.
Yes. My lord, I appear for the plaintiff.
Yes, yes.
The plaintiff filed an application under section 27 of the Special Marriage Act for dissolution of marriage. My lord, thereafter, during the pendency of the marriage, my lord, divorce petition, my lord, an RTI application was filed by the plaintiff before the registrar upon, my lord, the change of, my lord, the advocate, wherefrom, my lord, your petitioner came to know that, my lord, the entire registration was a product of fraud. And my
Of what?
registration of the marriage registration was a product of fraud, because the marriage registrar herself was barred from registering any marriage post 2016, whereas she has registered the marriage of the petitioner in the year 2021, my lord, in an it's absolutely fraud which has been committed. And my lord, no certificate, my lord, online certificate was ever issued. My lord, if your lordship kindly comes to the reply, my lord, I have filed a supplementary affidavit. Supplementary affidavit. My lord, kindly sees the supplementary affidavit at page 4. At page, your lordship prior to that kindly comes to, yes, page 4 is the answer of the RTI authority, is the answer of the Registrar General of Marriages. Supplementary affidavit কোথায়? Where is the supplementary? File হয়েছে মানে দেখুন তো supplementary affidavit টা কিভাবে ফাইল করব?
You have served a copy on him?
Yes. My lord, served. Your lordship has got it? Yes. My lord, my lord, kindly comes to page 5 first. My lord, these are the queries that I have raised under, my lord, the Right to Information Act. That whether, my lord, kindly sees whether the copy of the marriage certificate of such and such issued under section 13 of the Special Marriage Act is registered by Shikha Taposhi, the marriage register, is valid or not. Whether, my lord, these are the queries. And my lord, answer is at page 4. My lord, since 2019, June 2019.
That is on merits of the amendment. What
Yes,
has happened? Your amendment has been rejected.
My amendment has been rejected. I have filed an application for Order 6, Rule 17 for amendment, which has been rejected on the sole ground that, my lord, a prayer for dissolution of marriage and nullity of marriage cannot alternatively coexist in the same plaint. That is the only ground stated. And my lord, I have, my lord, judgments in my favor passed by the coordinate bench of this honorable court, which says that, my lord, the prayer for dissolution of marriage as well as alternatively the prayer for nullity of marriage can coexist.
My lord, may I hand over? ওই এর জাজমেন্টটা কোথায়? My lord, may I hand over a compilation? Copy as compilation? I don't have a copy, but you can refer for the time. এটা নেই। My lord, kindly seize page 108 first. Yes. Srimati Nirupama Bishwas versus Dilip Kumar Bishwas. CO 254 of 2022. My lord, kindly seize. The revisional application arises out of an order dated such and such. By the impugned order, the learned court rejected an application challenging the maintainability of the matrimonial suit. It is the specific contention of the wife that the suit was not maintainable, as prayers for declaration that the marriage was a nullity and a prayer for divorce could not be made in the same suit. Relying on civil rules and orders, it is submitted that the application must not contain more than one prayer. Series of alternative prayers of the same kind could not be prayed for. Secondly, my lord, the prayer for the contention of time bird was also there. Now, my lord, kindly seize paragraph 3. The learned court.
Yes, I have seen. Paragraph 5 is the submission. Paragraph 6 is there. Yes. Yes, I've seen it.
Yes. So, my lord, my contention is that, my lord, it will not change the nature and character of the suit if an alternative prayer for nullity of the marriage or annulment of the marriage is being added to the suit. And your lordship kindly sees the proposed amendment. Proposed amendment, your lordship will see at page 59 of the application. Page 59, the bottom portion, my lord, kindly sees schedule proposed amendment that in the cause title along with the suit for dissolution of marriage under section 27 as well as a decree for nullity shall be added. And that is what, my lord, the prayer also contains. And my lord, this nullity, the prayer of nullity is proposed to be added, my lord, as a subsequent, my lord, knowledge that your petitioner had obtained during the pendency of the dissolution of marriage application. So, my lord, I humbly submit that, my lord, there is no bar that both the prayers of dissolution and nullity can alternatively, my lord, coexist in the same suit. And my lord, the prayer is at, my lord, page 61, 11. Page 61, 11, the proposed.
In this you have not prayed alternatively.
Yes, my lord, clause 1 of the prayer portion shall be referred as a decree for nullity declaring the marriage to be void ab initio. Clause 2, that clause 2 shall be inserted in place of the present prayer. Thereafter comes the other.
Yes, but it is not alternatively.
No, my contention is that both the prayers can alternatively coexist.
Alternatively means one or the other.
Or the other. Yes.
So this means both.
This means both, my lord, but the fact
clarified.
remains that alternatively I can pray for, my lord, nullity. That is my
So you will
submission.
have to amend this accordingly. You will have to pray for alternatively, or the court can grant that.
Yes.
What is the problem? Why should this not be allowed?
The first issue is nature and character changes.
Prayer that you have seen those decisions. He has cited the decisions.
They are suit in this instance to suit.
Making an alternative prayer for nullity of marriage, if it is dissolution of marriage, your defense will be the same.
On the ground of Milord cruelty. Now they have admitted the marriage. Now
that is on merits. That is on merits. Why should the amendment not be allowed?
It changes the nature and character.
It doesn't change. That is what the judgments say. It doesn't change.
Then let me come back with some judgments.
What come with judgments? You should have come with judgments.
Kindly give me.
Those are judgments, sir. Judgments copies are not supposed to be said every time. You should have come ready. Come tomorrow.
Tomorrow, kindly Monday.
Monday, my lord, 7 except Monday, any other day, my lord, subject to your lordship's pleasure. 16th, your lordship, 16th. হবে?
An adjournment is prayed for. Affidavit of service filed in court today is taken on record.
Lordship, I am appearing with the petitioner Lordship. Defendant number 1 and 3 in the court below are present petitioner Lordship. I almost conclude my hearing and also cited.
Don't forget that you start
Lordship,
now.
start Lordship. The fact is that suit for declaration permanent injunction filed by the plaintiff. Cancellation of the deed, alternatively recovery of money. Fact is that the plaintiff executed a deed of sale in favor of the defendant. They filed a suit claiming that the entire consideration money was not possessed. So that paying for the decree that the sale deed is void, alternatively pay the entire amount. Initially, defendant appeared and by filing vocal nama and praying for time, but that was Lordship. I place showing the whole order sheet I annexed. Lordship, kindly come to page 31, Lordship.
Yes, 31.
Order number 7.
Yes.
PO's transfer, plaintiff file Hajira. Defendant number 1, 2, 3, 5 file fresh vocal nama and by petition praying for time for WS. Pair is allowed and they have already appeared on 22nd February 2020 as per order number 5. Hence the suit will run ex parte against the defendant number 1 to 5.
And you were for which defendant?
1 and 3.
The suit will run ex parte against you also.
Loss. Thereafter suit run ex parte. Ultimately, before argument, I filed an application under Order 9 Rule 7. That was rejected. That is the impugned order.
Order 9 Rule 7 for what?
For setting aside the ex parte degree and also file the WS. That application was rejected.
So you you file the WS along with Order 9 Rule 7. You want acceptance of that WS?
WS. That was another petition, and also file an application another petition. That was rejected. That is
Order
the
9 Rule 7 you will be allowed to participate, but WS you will not be allowed. You allowed to participate, you participate in the arguments, whatever is there, participate in cross-examination. But WSC will not be allowed merely because the court has said that prayer is allowed. You have to read with the other line also. Suit will run ex parte.
Yes.
If it is ex parte, where is the question of you being allowed to file WS?
I praying for order 9 rules. I praying for setting aside the ex parte order, Lordship. Order 9, I place the order 9 rule 7.
For ex parte order, it will go back to the next date. That means you will be allowed to participate.
Yes, Lordship.
That's it. So participation will be there, but so far as WS is concerned, you will not be allowed.
Yes, I place the order rule 7 laws.
Place.
Procedure where defendant appears on day adjourned hearing and assign good cause for previous non-appearance. Where the court has adjourned the hearing of the suit ex parte and the defendant at or before such hearing appear and assign good cause for his previous non-appearance, he may upon such terms as the court direct to cost or otherwise he be heard in answer to the suit. Be heard in answer to the suit as if he had appeared on the day fixed for his appearance.
Yes, that I am also saying you will be entitled to appear. Appear and contest.
Answer means the without.
Answer means your WS will be taken after 6 years. That is not what answer means.
But impugn my order 9 rule 7 application was rejected.
That I will say that order 9 rule 7 you will be entitled to contest the suit in accordance
on
with
the
law.
ground. Lordship, I placed the impugn order on the ground that the remedy is available under order 9 rule 30. Order 9 rule 30 is separate thing after disposal of the suit.
That is I will clarify.
Yes.
You will be entitled to contest if the evidence is over or evidence is going.
Evidence over. Date fixed for argument.
The argument stage,
The argument stage you are coming.
This
You
is
participate
absolutely
in
a
the argument.
direct.
Go and argue. You
Yes,
can argue.
Lordship,
You will be entitled to-
They are well aware of the proceedings. They have been served
You will be
duly
entitled
served
to
with
argue.
the
Not
summons.
Lordship, I
They waited for 6 years.
extend Lordship.
Not
I already
Just to-
cited decision reported in AI 1964 Supreme Court, page 993, paragraph 3, 4, 15, 19, and 20.
Yes, you will be entitled to argue. Even I am saying that.
Yes, that judgment also saying that clock back. That was
Show me that.
yes.
Show me.
First Lordship, I already supply the copy Lordship.
Yes.
1964 Lordship.
64, yes. Arjun Singh.
I only placing the relevant portion Lordship.
Yes.
Lordship, paragraph number 19 Lordship. Almost last portion Lordship. Paragraph 19 page Lordship.
And what is the good cause? It says that upon showing good cause. Show me the cause. What was the cause for which you were
36.
prevented?
36, their application. For page 36.
Yes, that is the test. For putting the clock back, you have to show the good cause. Show the cause.
36, their application.
What is the cause here? Page 36.
Lordship, I am showing it.
Show the cause.
Lordship. দরখাস্ত ফরিদ খান দিন 1-3 নম্বর বিয়াদিগণ নিবেদন এই যে অত্র মোকদ্দমায় অধীনগণ অত্র বর্ণনাপত্র দাখিল করিতেছি অধীনগণ খাটাখাটনির জন্য বাইরে থাকায় যথাসময়ে উকিলবাবুর সহিত যোগাযোগ করিতে পারে
না অধীনগণ what is the next word after that?
অধীনগণ খাটাখাটনির জন্য
They could not contact
অন্য বাইরে থাকায় যথাসময়ে উকিলবাবুর সহিত যোগাযোগ করিয়া বর্ণনাপত্র প্রকৃতির মতে দাখিল করিতে পারে নাই সে কারণে অধীনগণের বিরুদ্ধে শোকজ এর আদেশ হইয়াছিল অধীনগণ ইচ্ছাকৃত কোনো ত্রুটি করে নাই সে কারণে অধীনগণের অনিচ্ছাকৃত ত্রুটি
And when was the show cause first issued?
তো শোকজ order sheet Lordship.
Yes,
2022.
Yes,
Perhaps in order number 5, my lord.
And when was this application filed?
This application in 2025. 2nd April 2025.
Lossi, I,
At the bottom of page 26,
page
36.
30, Lossi. Whole order sheet I annex, Lossi.
That you have annexed, but please answer the question. Don't
Yes,
take
yes,
me through the
sure.
whole order sheet. Time is less.
Yes.
You finish it fast.
Lossi, order number 5, Lossi. Page 30.
Yes.
PO is on leave. Record is put up today by petition. Filed by the defendant. Defendant number 1 to appear today. Will vocal number and by petition pray for time for filing WS. PR is allowed. 6 Lossi. PO is on leave. Petition file Hajira. Defendant number 1 to 5 file a petition praying for time for filing WS. PR is allowed. No SR received. Fixed answer SR. Next date 7 is expertise. No show cause.
Very well. No show cause.
Expert.
You could have made an application there and then. Why
Loss.
should you wait for the court to make ask for a show cause?
This is also my fault. Also, that in that day I file an application.
Where is the law that the court has to issue first show cause and then that is a convention?
No, I cannot submit to that extent.
Then
order number 7. My application for time for filing WS is allowed.
Very well. But you filed it on the next date.
What
did you file on the next date?
No.
Then
on the next date, I have not.
It was allowed on that date. You did not avail of the opportunity. Go on.
That was passed on 7th December 2023. 7 December 2023. 7 December. I filed an application on 11 April 2025. That order was passed December 2023. I filed an application 11 April 2025.
No, Mr. Das, you can only participate in arguments. No case for putting the clock back because your application does not inspire confidence of court.
Well, Lossi, day labor can be Lossi. Day labor can was kindly considered to that extent, Lossi.
Difficult, very difficult. I have to only the other side also. I cannot shut my eyes to the other side. So there is another side also.
No, also seen the whole order. See, only 4 or 5 days gone between the period. Lossi, only Lossi, kindly see the order. I say posting order number 7 expertise. I file an application.
Just imagine the consequence. The entire suit will be turned down to the stage of written statement, evidence again, cross-examination. This suit will carry on for 10 years.
Lossi, kindly consider only one thing, nature of the suit. They executed all the sale deed in favor of me. They praying for the cancellation of the deed. Otherwise, pay the rest amount. If I am not appear, then Lossi, court can pass order.
Should have shown appropriate cause. The cause is not sufficient.
In future, Lossi, multiplicity of
moment you say khata khatnir jonne, what kind of khata khatni? Where?
Day laborer every day, one place to another place when they are lost.
These submissions can arise. Can give rise to sympathy, but I cannot turn the law. Absolutely, you have to give some handle. Pray something, write something in the application that makes sense. Merely because of this, I cannot put the clock back 3 years. By 3 years, it becomes very difficult.
No, only 1 year, Lossi.
Why 1 year?
Lossi,
you have made your application in 2025.
Lossi, kindly see.
You have made your application in 2025.
Yes, your expertise order, Lossi.
Expertise order was passed on 7th of December 2023.
I filed an application on 11th April 2025.
Yes. So
in between 1 year, 4 months.
1 year is sufficient.
1 year, 4 months, not a 3 years loss.
Sufficient. Please don't press these applications, they become difficult. This revisional application is directed against an order dated January 29, 2026, passed by the learned civil judge within bracket senior division, second court at Kontai, in title suit number 240 of 2022, whereby the petitioner's application under Order 9, Rule 7 of the Code of Civil Procedure has been rejected
Matter was heard by a lordship, not that section. Yes, I have taken instruction. It has been. Yes.
I've got the certified copies also.
Yes, I have taken.
Actually, that day, when I submitted that it is restored, I checked the order of February by which it was restored. It was available online, but I thought that it's better to produce.
ওদের official website এ দেখাচ্ছিল
It is recalled under the miss case, and then in fact, all our arguments are over. I have submitted a division bench judgment of the Bombay High Court on section 200.
May I submit one? Your lordship can reserve the judgment past any day. If you lordship.
By junior, much obliged. No, I thought, Lord, it is also my duty to state the correct things. I checked up then I said that you better get the certificate. Much obliged. Much.
24, my lord, I am appearing for the petitioner.
I am appearing for the opposite party.
I have served a copy of the civil divisional application.
I have received. No.
This is my affidavit of service. Lord, in this matter, it's a suit for eviction, my lord. The petitioners are the tenants. Lord, in an application under section 7.2, my lord, the learned trial judge has decided the matter by solely relying upon the plaintiff case and the oral submissions made by the plaintiff landlord. My lord, it is the case, my lord, that rupees 250 is the monthly rent, but the plaintiff's case is that 1200 is the monthly rent. Now, my lord, I have annexed certain receipts, rent receipts in the application under section 7.2. Those have been considered and held that these are prima facie, the signatures appearing in the rent receipts has not been made by the plaintiff. On the other hand, my lord, the documents attached with the plaintiff case, annexed with the plaintiff, my lord, those have been considered, and my lord, rupees 1200 is the monthly rent the learned judge has held, my lord. My lord, it comes at page 46, my lord. After page 46, the order impugned. After page 46, my lord. Well, should I place the entire order? Should I place the entire order, my lord? My lord, then straight away, my lord, will come look into 2 pages, my lord, after page 46, the first page, second page, and third page, my lord. Peruse the record carefully on careful second last page of the impugned order, third last page of the impugned order. My lord, page 3. On careful perusal of the record, it appears that these defendants are depositing rent under section 7.1 of the West Bengal Premises Tenancy Act since June 2025 at a monthly rate of rupees 250. Now, from the admitted rent receipt and the counterparts of the rent receipts filed by both the parties, it appears that previously the monthly rent was rupees 250 per month. Thereafter, it was increased time to time, and last monthly rent was rupees 1200 per month, excluding the electricity charges. Plaintiff also mentioned in the plaint that Ramvilas Sharma was the tenant under the plaintiff, and at the rate of rupees 1200 per month, payable according to English calendar month. The defendant number 1 and 4 filed a rent receipt dated such and such, which reflects that the rent paid up to June 2020, but the plaintiff denied the issuance of the rent receipt. by him, learned advocate for the plaintiff, during the course of hearing submitted that the said rent receipt dated 10/11/2020 is a manufactured one and the signature appearing on the said receipt is not of the plaintiff. My lord, while deciding the issue, my lord, no cogent reason has been, my lord, recorded, my lord, by the learned trial judge.
Reason is given there. Just a second. Rent
My lord,
receipt.
no, my lord. Rent receipt I have annexed.
Yes.
My lord, that, my lord, in my humble submission is a triable issue. Whether the signatures appearing in the rent receipt are those made by the plaintiff or not, well, that is a triable issue, my lord. On bare perusal of in my humble submission, my lord. Well, it's a question of trial, my lord. As to the genuineness, at least, my lord, one opportunity may be given. I am already paying. My lord, then we'll kindly put
Actually, 7-2 has to be decided on a revision because there is.
I am already paying the rent which I have. Yes, my lord. That I am doing, my lord. My lord, I am already doing that. These are the challenge, my lord.
Ask 2 points before. Lord,
Challenge.
the subject.
My lord.
That liberty has been given by your lordship.
That, my lord, liberty has been.
So far, with regard to this suit is concerned, Lord, so far my humble estimation, Lord, this suit has been, at least it has been made ex parte because, my lord, till date there is no WS. Till date, because there was an order. No. That is
WS has been filed.
No, WS has been filed, but will not subject to payment of cost of rupees 1,000 in the month of January. I am showing to your lordship. Your lordship, kindly see. This is the order.
My
Yes,
lord,
till date he has not paid the cost. And if there is no WS, how these two applications decided on merit? But without WS, can that be decided? Can that be asking myself, my lord? If that, because that makes this suit ex parte against him, because there is.
My lord, I have to take instruction. My lord. These, my lord, these.
I have the certified copy. Oh, I have the certified copy with me, right? And on 9th of January, it has been passed, subject to payment of rupees 1,000 cost. Till that, after even passing of this order, and they have filed.
Third paragraph.
Even the order impugn says that he has not paid rupees 1,000 cost in the second paragraph. Lordship, kindly peruse the order dated 9th of January. 9th of January. And the entire adjudication has been aparted, Lord, because your lordship, there is no WS. 7-2 has been. No,
I have to take instruction. Should I make a call, my lord?
26th, my lord, 3rd of June, my lord. My lord, may it be listed on Monday or Tuesday, any day convenient, my lord? Oh, as you wish. Any date, my lord. As you wish.
Can number 1, I have filed for mentioning modification of order. That was supposed to be listed on 9th, not there is one another application for urgent hearing. Thanks, my lord. Please keep in mind, I am cancer patient. At the time of fixing, keep that in mind.
না নাইস
সকাল থেকে বসে আছে গলা ও ও ও 1 মিনিট হ্যাঁ আমরা তো অন টাইম আমরা তো অন টাইম আমরা তো টাইমের কোনো
I remember, my lord, Mr. Pratap Chatterjee once saying it to Justice Sanjeev Banerjee in court number 16. Used to usually in his initial days sit beyond 4:30. So once he said in open court, all orders passed beyond 4:30 are without jurisdiction.
বলা কাউন্সিল এট সেকেন্ড
গলা ঠিক হয়েছে? ঠিক হয়েছে গলা?
বেটার
Yes. My lord, I appear for the petitioner, my lord. আছি আছি, তুই এদিকে আয়।
ফর দি অপোজিট
ও না, ডাকলো, দেখেছে, কল করেছে। তুই এদিকে আয়। করছিস, ওকে বলতে দিবি না নাকি? কি যাতা বলছিস তো? আমার ব্রিফটাই দেয়নি।
ছেলেগুলো কোথায় তিনটে ছেলে
জানি না, ব্রিফটা দেই ভাই। আমার this, my lord, 227 application, my lord, arises, my lord, against, my lord, an order passed, my lord, by the NCLT bench 2, whereby, my lord, I have filed an application for perjury, which, my lord, the tribunal wants to, my lord, hear out upon affidavits. Now, my lord, as I had shown at the stage, my lord, when the interim order was passed, that the law is well settled, that, my lord, in a perjury application, court will not, my lord, give a chance to, my lord, the person against whom I am seeking for an order of perjury to be invoked, to be heard at the first instance, because that is the law. And, my lord, he would be only asked to answer at the stage when it is referred to, my lord, the magistrate. Because, my lord, the perjury is then being adjudicated upon. Otherwise, there is no perjury. The court, if it finds, my lord, that there is no perjury, will dismiss it. If there is perjury, he will only, my lord, refer it for an investigation. The trial, my lord, is not before the court taking up the perjury application. And that is why that court does not permit, my lord, a respondent to be heard or given an audience, my lord, at that stage. Now, my lord, it can, in certain circumstances, where, my lord, the court finds that there is a requirement for the same, and, my lord, the court records the reasons in the order, and thereby directing, my lord, the respondent to file an affidavit or documents before taking up the matter, my lord, for admission and for transfer or for admission and dismissal. In this case, as I showed to my lord, the court has not come to that finding. Now, if the court has not come to that finding, then obviously, my lord, the law as it is settled, my lord, has to be followed, that it has to be heard, my lord, without an audience to, my lord, against whom I am seeking a perjury, because that is the law then. So, my lord, let me show, my lord, what is the, my lord, impugned order, and before that, what are the facts which led to the impugned order, why a perjury. My lord, in this, my lord, there is a section 7 application which was filed initially by my learned friend's client. No, there is a, I'll take just 5 minutes for that.
Because,
5 minutes.
At
Lord
this
will
stage,
not,
I
Lord
will
will,
not be
Lordship will
forming
not
opinion
dwell.
as to whether, yes,
Correct. Lordship
that
will.
is for the appropriate.
Absolutely, my lord.
Whether there is a perjury or not.
Absolutely.
We are at the propriety of the order whether the order could have directed issuance of notice on them
Correct.
for the purpose of filing
Correct.
their affidavit in response to your application.
Correct, my lord. But my lord, I need to show it because of a different reason, which I'll say, my lord, later. I'll just take 3 minutes. In a Section 7 application, my lord, initially, my lord, I was the respondent. I was not allowed to file, my lord, a written objection. I came before this court, and my lord, this court directed me to file the written objection, directed the tribunal to accept my written objection. No reply filed to my written objection, matter heard on my demurrer application, appealed, appeal court, the appellate tribunal directed the, my lord, tribunal below, my lord, to take up the matter with all points open. Now, my lord, the matter was heard. It was made CAV. At this stage, after 3 months, all of a sudden, my lord, the tribunal says, keep bringing the matter into the, my lord, list, saying that it requires certain clarification on a point which we have already argued. And I had shown, my lord, that on this point itself, the application should be dismissed. At this juncture, a document is disclosed, my lord, after CAV by the, my lord, respondent herein, against which I have filed the perjury application. Against that document, I have filed the perjury application because, my lord, I have a clean slate case, my lord, whereby I can show how perjury has been made. Now, my lord, in that, lordship will now see what is the impugned order without reasons. My lord, kindly takes the impugned order, page 30, my lord. My lord, kindly sees. This matter was listed for clarification by the bench, as I said, my lord. Upon clarification, it has been stated that the pleadings have been filed by the parties. At this stage, the corporate debtor has filed 2 applications, that is IA such and such, which is, my lord, for summoning, and IA such and such, which is, my lord, for was, my lord, 1519. The first one is for perjury, the second one is for summoning a witness. Let reply affidavit be filed in both these applications within a period of 7 days. Consequent upon filing of reply, rejoinder be filed within 10 days. List this matter with the main CP for hearing on such and such day. So therefore, my lord, admittedly, there is no reason stated why in this case of a perjury application, the court wants to hear out or wants to, my lord, certain documents to be filed by the respondent. No reasoning stated, my lord, admittedly in this order, my lord. Now, my lord, apropos this, when lordship passed the order, my lord, of interim order in my favor, lordship kindly takes up that order because lordship has reasoned it out there itself. If that order, my lord, is dated, my lord, 9th of March 2026. This revisional application is directed against an order dated January 5th, 2026, passed by the National Company Law Tribunal, Kolkata bench, thereby directing the opposite party to file reply affidavit in IA 1519 of 2025. Mr. Such and such appearing for the petitioner submits that the order impugned is wholly without jurisdiction, is as much as the learned tribunal has failed to appreciate that the Honorable Supreme Court has, in the case of Pritish versus State of Maharashtra, as well as subsequently in the case of State of Punjab versus such and such, clearly held that an application made under Section 340 of the Criminal Procedure Code, or 379 and 215 of the Bharatiya Nagrik Suraksha Sanhiti, the person complained against has no right to file any written objection to the application or to be heard. It is further submitted that in any case, even if it is assumed that the court required the version of the party concerned, it was incumbent on the court to first come to a conclusion. This is very important, my lord. Come to a conclusion that a preliminary inquiry was required for the purpose of arriving at a conclusion as to whether the complaint should be referred to relevant magistrate or not. Because I'll rely on the provisions, my lord, immediately to show why lordship has recorded this and why Supreme Court has also recorded in the order that, my lord, for a preliminary investigation, there has to be a reasoning in the order. Now, my lord, kindly sees. Then, my lord, kindly sees appearing for the petitioner and having perused the judgment of the Honorable Supreme Court in the case of such and such, this court is of the prima facie view that the National Company Law Tribunal has exceeded jurisdiction in passing a routine order, inviting reply affidavit in respect, my lord, that word is very important, routine order, from the opposite party without appreciating that there is no statutory requirement of affording an opportunity of hearing at the stage of considering an application under section 340 of the Criminal Procedure Code. In such view, my lord, Lordship has passed an interim order which is still there till the end of June. Now, my lord, why is it so? My lord, kindly takes the provision. My lord, kindly, this is the new, my lord, act which we must follow now. Copy আছে? দাও। এই তো আছে। এই তো copy, হাতে ধরে।
Lord will kindly take this for the time being. I'll take it back later. I can't pronounce the names, my lord, unfortunately.
Bharatiya Nagrik Suraksha Sanhiti. Sanhiti 2023. BNSS.
Yes.
My lord, kindly comes to 379, my lord, section 379. My lord, kindly sees, my lord, 379 first, then I'll show 215 also.
Yes.
When upon an application made to it in this behalf or otherwise, any court is of opinion, because, my lord, this is at the opinion stage, opinion, that it is expedient in the interest of justice that an inquiry should be made into an offense referred to in clause B of subsection 1 of section 215, which appears to have been committed in or in relation to a proceeding in that court, or as the case may be, in respect of a document produced or given in evidence in a proceeding in that court, such court may, after preliminary inquiry, the word is preliminary inquiry, if any, as it thinks necessary, record a finding to that effect, make a complaint thereof in writing, send it to a magistrate of the first class having jurisdiction. Now, my lord, we have not even reached that stage. We have filed an application which is to be, my lord, inquired into by the court, as lordship has recorded in the prima facie, my lord, opinion that lordship has expressed also. And, my lord, therefore, the question of hearing the respondent under the act itself is not there. Thereafter, my lord, the court, upon my petition, will form an opinion. Lordship, my lord, there is no finality in that. If, my lord, today I come up with a perjury before my lord, lordship will only, my lord, prima facie form an opinion and send it, my lord, to, my lord, a court of jurisdiction, or my lord, lordship can even give a finding to that effect, and, my lord, call for the other side for affidavits, or, my lord, will send it to the magistrate, my lord, with that prima facie opinion, my lord, to investigate. And that is the stage, my lord, wherein he will get, my lord, a show cause to answer before the magistrate in the investigation. Because when I will take, my lord, to the other provisions, lordship will find that what is the work of the magistrate. The magistrate gives him that option, my lord, to answer the question of perjury before him. Otherwise, what is happening, my lord? The trial is taking place before the court where I have filed the perjury application. And that is not the law. Otherwise, my lord, it is not an opinion finding court. It would be, my lord, a fact finding court. And that is exactly what the, my lord, impugned order has done. It has become a fact finding court or an investigating court, which the jurisdiction is not clothed with. The jurisdiction, my lord, is, my lord, with the magistrate. And there he exceeds the jurisdiction in the impugned order by saying, no, on affidavits, I'll hear out the matter. Because, my lord, if lordship sees, my lord, page 906 of my application, because this is very important, my lord, I have drafted it, or my juniors have drafted it, my lord, considering the provision of law. At 906, my prayer is that. Kindly sees, my lord, my prayer K. My lord, this is in volume 6, my lord. The last volume 6. Take to them. Kindly takes, my lord, page 906. The prayer starts, the application starts from page 863. And, my lord, the relevant prayer, lordship will find at 906, prayer K. Kindly sees my prayer, an inquiry being made into the offences committed by the accused persons, namely such and such, such and such, such and such, within the meaning of the provisions of the Indian Penal Code, read with the provisions of section 195 and section 340 of the Code of Civil Procedures 1973, read with section 215 and 379 of the present Act, my lord, in relation to the above proceeding in the manner described more fully therein. So, my lord, that's my specific prayer. Now, my lord, kindly sees apropos this. And my prayer end, if your lordship sees, my lord, I have also, my lord, made a specific prayer end, whereupon, if my lord, upon inquiry, he forms an opinion that there is an offense, then, my lord, he would refer the matter to this Chief Metropolitan Magistrate, Kolkata, having jurisdiction in the matter, with a direction to institute appropriate criminal proceedings against the accused as stand. Otherwise, my lord, if that is being done by what has been done in the impugned order, then, my lord, the jurisdiction of the magistrate is being used up by the, my lord, tribunal itself. Now, my lord, apropos this, kindly now takes, my lord, 215.
Can I take your lordship's leave for 1 minute, my lord?
Yes.
I mean,
215, my lord, as I said. Now, my lord, why this is being defined in 215? My lord, kindly sees prosecution for contempt of lawful authority of public servants or offences against public justice and for offences relating to documents given in evidence. I am on this because I am relying on that document itself.
Page 215.
No, my lord, section 215 of the Act, my lord, of the same Act. 215. I'm sorry, my lord.
Section 215. Yes.
No court shall take cognizance of an offence punishable under sections 206 to 223, then, my lord, of any abatement or attempt to commit such offence or any criminal conspiracy to commit such offence, except on a complaint in writing of the public servant concerned or some other public servant to whom he is administratively subordinate, or to some other public servant who is authorized by the concerned public servant so to do, of any offence punishable under any of the following sections of Bharatiya Nyaya Sanhiti 2023, namely, then, my lord, the provisions are quoted. Thereafter, lordship will kindly come to, my lord, 3, my lord. Of any criminal conspiracy to commit or attempt to commit or the abatement of any offence specified in subclause 1 or subclause 2, except on a complaint in writing of that court. Now, my lord, lordship remembers, my lord, the section 379, my lord, C. Now, my lord, when the court finds, my lord, comes to an opinion Lordship sees, my lord, thereafter it can send it to a magistrate. Now, my lord, under this, if the court, my lord, in writing comes to an opinion, then, my lord, kindly sees what happens, my lord, or of that court or any such officer of that court, as the court may authorize in writing in this behalf or some other court to which that court is subordinate, where a complaint has been made by a public servant or some other public servant who has been authorized to do so by him under clause A of subsection 1, any authority to which he is administratively subordinate or who has authorized such public servant may order the withdrawal of the complaint and send a copy of such order to the court. Upon its receipt by the court, no further proceedings shall be taken again on the complaint, provided that no such withdrawal shall be ordered if the trial in the court of the first instance has been concluded. In clause B of subsection 1, the court means a civil, revenue, or criminal court, and includes, my lord, a tribunal constituted by or under a central or state act. And this is very important, my lord. Lordship knows the NCLT is a tribunal which has been formed under the central act of, my lord, IBC. Now, my lord, if declared by the act to be a court for the purpose of this section, then, my lord, kindly sees the appeal provisions of the. Therefore, my lord, as I say, my lord, first is 379, my lord, whereby, my lord, an opinion is formed. Second is, my lord, on the basis of the opinion, my lord, it refers to a court of magistrate to, my lord, take cognizance and file a complaint against that person. Because, my lord, my perjury is not a complaint. And when a complaint is filed, he gets a chance of representation. At the, my lord, threshold, since there is no complaint, the question of audience does not arise at all. And if it is so, then there has to be a reasoning in writing, as I read out, my lord, in the stage, at the stage, my lord, when, my lord, such direction is passed. Now, my lord, apropos this now takes the judgment which the Supreme Court has delivered, my lord, saying that there is no right of audience. Now, Lord, kindly takes the judgment of Pritish once again, because now, my lord, Lordship has, my lord. My lord, kindly takes then para 12, my lord. This deals with identically the same case. Copy. Dear. I'm always the. My lord, kindly takes paragraph 12. My lord, at page 259.
Yes.
Thus, the person against whom the complaint is made has a legal right to be heard whether he should be tried for the offense or not. My lord, I stop here. Kindly, my lord, visualizes the word complaint is at the stage when the magistrate is taking up the matter. Because before the tribunal or the court, at the stage of the perjury application, there is no complaint. The Supreme Court has been, my lord, very skeptical about the words. But such a legal right is envisaged only when the magistrate calls the accused to appear before him. The person concerned has then the right to participate in the pre-trial inquiry envisaged in section 329 of the code. It is open to him to satisfy the magistrate that the allegations against him are groundless and that he is entitled to be discharged. So, my lord, reading paragraph 12, it is absolutely clear that, my lord, his stage of his, my lord, chance to, my lord, deal with the allegations is before the magistrate where the complaint is, my lord, drawn up. Then, my lord, the scheme delineated above would clearly show that there is no statutory requirement to afford an opportunity of hearing to the persons against whom the court might file a complaint before the magistrate for initiating prosecution proceedings. Learned counsel for the appellant contended that even if there is no specific statutory provision for affording such an opportunity during the preliminary inquiry stage, the fact that an appeal is provided in section 341 of the code, any person aggrieved by the order, is indicative of his right to participate in such preliminary proceeding. So exactly what I'm arguing, my lord, was the question before the Supreme Court. Now kindly takes 14.
Section 341 of the code confers a power on the party on whose application the court has decided or not decided to make a complaint, as well as the party against whom it is decided to make such complaint, to file an appeal to the court to which the former court is subordinate. But the mere fact, Lordship will kindly mark here, but the mere fact that such an appeal is provided is not a premise for concluding that the court is under a legal obligation to provide an opportunity to the persons against whom the complaint would be made to be heard prior to making of the complaint. So there is no statutory obligation, my lord, on the court. Rather, the statutory obligation is not to give him a chance. Then, my lord, there are other provisions in the code for reaching conclusions whether a person should be arraigned as accused in criminal proceedings or not. But in most of those proceedings, there is no legal obligation cast on the court or the authorities concerned to afford an opportunity of hearing to the would-be accused. In any event, the appellant has already availed of the opportunity of the provisions of Section 341 of the Code by filing the appeal before the High Court as stated earlier. In this case, the appeal was filed. Now, my lord, kindly comes to 15. Once the prosecution proceedings commence, the person against whom the accusation is made has a legal right to be heard. So that's at the magisterial state, my lord. Such a legal protection is incorporated in the scheme of the code. Principles of natural justice, my lord will kindly mark this, would not be hampered by not hearing the person concerned at the stage of deciding whether such person should be proceeded against or not. So, my lord, his argument that my natural justice principles are hampered is not at this stage, but at the stage if there is an opinion formed and complaint drawn up against him. Be it noted that the court at the stage envisaged in Section 340 of the Code is not deciding the guilt or innocence of the party against whom proceedings are to be taken before the magistrate. At that stage, the court only considers whether it is expedient in the interest of justice that an inquiry should be made into any offense affecting administration of justice. In Messrs. Sheriff versus State of Madras, a constitution bench of this court cautioned that no expression on the guilt or innocence of the person should be made by the court while passing an order under Section 340 of the Code. An exercise of the court at that stage is not for finding, as I said, my lord, it's not a fact-finding court, whether any offense was committed or who committed the same. The scope is confined to see whether the court could then decide on the materials available that the matter requires inquiry by a criminal court and that it is expedient in the interest of justice to have it inquired into. My lord, I stop here for one issue to, my lord, highlight. Otherwise, what is happening, my lord, the criminal jurisdiction or the jurisprudence of, my lord, is being clothed to the tribunal, which undoubtedly, my lord, the company law NCLT does not have, my lord. Otherwise, my lord, as I said, it is, my lord, stepping into my lord, the adjudication stage, my lord, which it is not clothed with. And that is why my 227 before this honorable court, that it has exceeded its jurisdiction. And that's exactly what the Supreme Court says, my lord, that scope is not there where the application is filed. Then, my lord, kindly sees, my lord, the judgments have been referred to. Then kindly comes to, my lord, 18. Straight away, my lord, kindly comes to 18. We are unable to agree with the said view of the learned single judge, as the same was taken under the impression that a decision to order inquiry into the offense itself would prima facie amount to holding him, if not guilty, very near to a finding of his guilt. And that's not the case, my lord, under the provision. We have pointed out earlier that the purpose of conducting preliminary inquiry is not for that purpose at all. The purpose of the would-be accused is not necessary for the court to decide the question of expediency in the interest of justice, that an inquiry should be held. we have come across decisions of some other high courts which held the view that the persons against whom proceedings were instituted have no such right to participate in the preliminary inquiry. So therefore, my lord, not only the Supreme Court but high courts also has held, and my lord, the reference is given, my lord, of Muttuswamy, my lord, wherein the High Court has also held that at that stage, my lord, no, my lord, right of audience is given to the person against whom, my lord, I make, my lord, a allegation at all. It is for the court to make an inquiry. But this is also, my lord, fortified by another judgment of a constitution bench judgment reported, my lord, in 2005 4 SCC, page 370. Copy আছে? না ওকে দিতে হবে, তোর আছে? Well, it kindly comes to well, it kindly comes to paragraph 23, my lord, which is at page 386, my lord. And this is a constitution bench judgment, my lord. My lord, in view of the language used in section 340 of the lordship has got it, my lord.
Yes.
340 of CRPC, the court is not bound to make a complaint regarding commission of an offense referred to in section 195 1B, as the section is conditioned by the words, court is of opinion that it is expedient in the interest of justice. This shows that such a course will be adopted only if the interest of justice requires and not in every case. Before filing of the complaint, the court may hold a preliminary inquiry. Now, this is very important because this would be the, my lord, I believe the submission of my learned friend that there is a little scope also to call for me. My lord, when? Kindly sees, my lord, Supreme Court, my lord, Constitution bench has cleared that doubt also. May hold a preliminary inquiry and record a finding to the effect that it is expedient in the interest of justice that inquiry would be made into any of the offenses, should be made into any of the offenses required in section 195 1B. This expediency will normally be judged by the court by weighing not the magnitude of injury suffered by the person affected by such forgery or forged document, but having regard to the effect or impact such commission of offense has upon administration of justice. It is possible that such forged document or forgery may cause a very serious or substantial injury to a person in the sense that it may deprive him of a very valuable property or status or the like. But such document may be just a piece of evidence produced or given in evidence in court, where voluminous evidence may have been adduced, and the effect of such piece of evidence on the broad concept of administration of justice may be minimal. In such circumstances, the court may not consider it expedient in the interest of justice to make a complaint. So it is for the court to decide. The broad view of clause B subsection II has canvassed by learned counsel for the appellants would render the victim of such forgery or forged document remediless. Any interpretation which leads to a situation where a victim of a crime is rendered remediless has to be disregarded. Now, my lord, kindly takes apropos this paragraph, my lord. My lord, 24, my lord, kindly takes the first few words, my lord, lines rather. There is another consideration which has to be kept in mind. Subsection 1 of section 340 of CRPC contemplates holding of a preliminary inquiry. Normally, a direction for filing of a complaint is not made during the pendency of the proceeding before the court, and this is done at the stage when the proceeding is concluded and the final judgment is rendered. Section 341 provides for an appeal against an order directing filing of the complaint. So therefore, my lord, if he is aggrieved, he has a right of appeal. But at that stage, my lord, even my lord, he does not have, my lord, the right of audience unless there is a finding given, my lord, of such, my lord, in the order itself, saying that yes, we have had a preliminary opinion upon inquiry that there needs to be certain things which we require a clarity from the, my lord, respondents. Otherwise not. Now, my lord, there is one more judgment, my lord, of a latest judgment, my lord, of 2022 SCC online, page 1.
This you had submitted on the last occasion.
Yes, I have given. He was not there, so therefore, my lord, I should not keep him in the dark. My lord, kindly takes, my lord, the first paragraph itself. This was out of a reference because this is a larger bench which was formed, my lord. The matter has been placed before the 3 judges bench arising from a reference made by an order 26 to 2020 seeking the following questions to be answered. Now, my lord, kindly sees those questions. Whether section 340 of the Criminal Procedure Code 1973 mandates a preliminary inquiry and my lord, this is very important, and an opportunity of hearing to the would-be accused before a complaint is made under section 195 of the code by the court. Now, this is exactly again the same question which Lordship is hearing, my lord. What is the scope and ambit of such preliminary inquiry? Now, my lord, kindly comes to paragraph, my lord, 5. Kindly comes to paragraph 5. To put the aspect in the right perspective and in sequence, we may note the first judgment of the 3 judges bench of Pritish versus State of Maharashtra, which I showed, my lord, which noticed that the purpose of a preliminary inquiry under section 340 subsection 1 of the CRPC was not to find whether a person is guilty or not, but only to decide whether it was expedient in the interest of justice to inquire into the offense. It was thus observed that the court is not obliged to make a preliminary inquiry on a complaint, but if the court decides to do so, it should make a final set of the facts which is expedient in the interest of justice that offense should be further probed into. Now, my lord, kindly comes to 6. The reference order is a conflicting view in Sharad Pawar versus Jagmohan Dalmia to the extent that in paragraph 7, while noticing the submissions of the council, it was observed that it was necessary to conduct a preliminary inquiry as contemplated under section 340 of CRPC, and also to afford, my lord, kindly will mark this, and also to afford an opportunity of being heard to the defendants, which was admittedly not done. The latter was stated to be contrary to the view in Pritish's case. So, my lord, if upon hearing my lord case made out in, my lord, perjury, ideally the court should not go into a preliminary inquiry, my lord, form an opinion and send it to the magistrate. Now, my lord, if a case arises that, my lord, the court feels that I should go into a preliminary inquiry, then only, my lord, the situation arises for hearing the other side, otherwise not. And that's exactly what has been, my lord, stated here. Now, my lord, kindly see 7. The reference order also simultaneously noted the observation in the constitution bench of this court in Iqbal Singh, which, my lord, I just handed over, which was post the judgment in Pritish's case, but prior to the judgment in Sharad Pawar's case. In this behalf, the extracted portion in paragraph 23 of the judgment reads as follows, my lord, which I stated. Now, my lord, kindly comes to 8. On having considered the matter, it is our view that the constitution bench view would naturally prevail, that makes the legal position quite abundantly clear. Not only that, if we may notice, what is reported in Sharad Pawar's case is only an order and not a judgment. An order is in the given factual scenario. The judgment lays down the principles of law. The scenario is that any order or judgment passed by this court becomes a reportable exercise to create more volumes of reported cases. This thus has a possibility at times of causing some confusion on the legal principles prevalent. The observations in the quoted paragraph extracted aforesaid apparently came out of the flow of the order rather than pronouncing any principles of law, and that is why the bench itself categorized what is observed as an order, that is in the given factual scenario. We have little doubt that there is no question of opportunity of hearing in a scenario, my lord will kindly mark it, in a scenario of this nature, and we say nothing else but that a law as enunciated by the constitution bench in Iqbal Singh Marwa's case is in line with what was observed in Pritish's case. Interestingly, both the judgment in Pritish's case and the Constitution Bench judgment in Iqbal Singh Marwa's case have not been noted in the order passed in Sarath Pawar's case. The answer thus to the first question raised would be in the negative, and therefore, my lord, there is no opportunity which is to be given. Now, my lord, apropos this, if your lordship sees the impugned order, my lord, I have a classic case where, my lord, even a preliminary inquiry has not been even, my lord, drawn or thought of by the court. A routine order of direction for affidavit has been passed and an opportunity has been given to him to participate, which in fact cannot be even thought of. My lord, considering these cases, which cannot be thought of even, because the court has to come to a finding to give him an opportunity. So, my lord, apropos this, I say, my lord, that the order is impugned and, my lord, it should be set aside. And, my lord, the perjury should be heard without an opportunity being given to him. If the court comes that there should be not opinion, but a preliminary investigation or inquiry, then only he should be called for, otherwise not, with a finding.
Yes,
those are my sufficiencies.
Lord, first of all, Lord, I'd like to formally raise the objection of maintainability, because this is an order passed, Lord, under the regime of the Insolvency and Bankruptcy Code. As your Lordship is aware, Section 61 permits appeal from any order before the NCLAT. My Lord, just for, my Lord, a formal objection, I'm taking that because this appeal, this 227, otherwise,
he'll meet it.
I'll meet it immediately.
It's really not maintainable. His answer will be, if you exceed jurisdiction, I am, but you should not, unless you don't have an alternate remedy. You have an alternate remedy which is efficacious, if you are aggrieved. Now, my lord, there are two answers broadly that I have, and I'll expand on that. May I give your lordship the 2 points, and then I'll elaborate on each point separately. Now, the legal position, as I understand it, based on reading 379-215 and my learned friend's own judgments, is, my lord, though there is no right that I have to demand, my lord, an opportunity to file an opposition or a reply, the court is not denuded of the power to do so for the purpose of preliminary inquiry. And all that the court will do is that the court will conduct the preliminary inquiry and see whether it meets the test of 379 read with 215, which is 340 read with 195. I will show from his own judgments that a distinction has been drawn between obligation of court to mandatorily give me an opportunity. Because under the rules, in a normal application, I have to, as a matter of right, be given an opportunity if I want to file a reply or an opposition. Here, I don't have it as a matter of right. But the court can always give it to me. I can't say, I can't come before your lordship and say that the court has refused me. Please help me. I can't do that. But if the court has given it to me, that's the court's prerogative, which is not taken away even in the judgment. That is
so there is no jurisdictional error.
Correct. And my lord, I'll show that from his own judgment. The second, my lord, answer is a more substantial answer because it's on fact. What has not been told to your lordship is, my lord, 4 things. Firstly, my lord, this is a Section 7 matter for 27 odd crores filed in 2023. This matter has seen him come to the 227 court for the 3rd time. Your lordship is aware of that jurisdiction. This is the 3rd 227 is preferred in the same matter, not having achieved success in the first 2. This matter has travelled all the way up to the appellate tribunal on a demurrer which was dismissed. He filed a demurrer to my Section 7, dismissed. NCLAT said, why are you filing so many demurrers? Have the main matter heard out. So, my lord, this matter has seen 8 forums to decide, my lord, a defaulted claim of 27 crores. What has not been told to my lord is that along with the perjury, he has, in the perjury application itself, made other prayers saying that you shouldn't be allowed to rely on the documents. There should be an interim stay of the CP, that these documents should not be taken into consideration. Now, if I ask myself a question, Lord, am I not permitted to at least respond to those prayers? You have, in your wisdom, decided to expand the scope of the IA. Had it been, my lord, a 379/215 simpliciter 4 paragraphs with 2 prayers, preliminary inquiry and send it to the magistrate, I could have still understood. But having chosen, my lord, to include 3 other prayers which go to the substance of the dispute, which are interim reliefs to scuttle the hearing, can he now be seen to argue that I should be denuded of my right to respond to even those prayers? My lord, I'll show that. More importantly, what has not been told, and my lord, with your lordship's leave, I'll hand it up to you. Before the tribunal, on the same day, please make a note, the perjury is filed on 11th of September 2025. Please make a note of this date. On the same day, he files 2 other pleadings before the tribunal. His pleading, I will hand up his pleading alone. He has filed a supplementary affidavit, and my lord, he has filed another application with the exact same subject matter as the perjury and asking for other reliefs. In the supplementary affidavit, he has said that the petition should be dismissed based on these false documents. And in the other IA, which is filed on the same day, it's a copy paste of the perjury, but he's asked for summoning of the officers, cross-examination under the rules, etc. Lord, pardon my voice, my lord, I've had a procedure, that's why it's slightly shaky. Take the mic. Now, my lord, having chosen not only to include prayers in the perjury, but concurrently filing 2 other pleadings on the same subject matter, he's invited the court to issue notice and file a reply. And please now, in this backdrop, kindly permit me to kindly come to the impugned order once, and then I'll make good my submission on the question of law, and I'll quickly, my lord, show these facts. My lord, I won't take too much time. Kindly come to the impugned order. This order was passed on the 5th of January 2026. Please see at the top, my lord, which were the interim applications under consideration. There was the CP. My lord, please make a note that he's filed a supplementary with the same facts as perjury in the CP asking for dismissal. I'll show that supplementary. He's suppressed it in his 227. I'm carrying that. I'll show it's verbatim same. Your supplementary affidavit in the tribunal.
There's no suppression into it. My lord, I'll make a submission. These submissions are very, my lord, glaring.
I did not
No, but then there's no suppression.
Suppression.
That's not required.
Very well. Let me rephrase. He has chosen not to disclose either the filing of it or the document itself. Whether it's suppression or not, your lordship will judge.
Yes, lordship.
Now, please see the other 2 IAs on board. IA 1519 is the perjury. IA 1520 is the cut copy paste of perjury with the prayer for summoning 7 persons to cross-examine, depose, and for, my lord, orders in the CP based on the false documents that have allegedly produced. Now, these 2 IAs came up for consideration together. Please see what the court has held. This matter was listed for clarification by the bench. Upon clarification, it has been stated that the pleadings have been filed by the parties. Now, at this stage, the corporate debtor, meaning him, has filed 2 applications, IA 1519 and 1520. And please take it from me, more or less identical. One paragraph here or there is different. Substance is different. Let reply affidavit be filed in both these applications within a period of 7 days. Consequent upon filing, rejoinder, list this matter along with me. So, having invited the court, I did not, in fact, I'll be frank, I did not ask for a reply. Court itself said you file a reply. I don't have the right to ask for it in 1519 on the perjury, but I have a right to at least defend it on the other press. Now, my lord, kindly, in this backdrop, let me show your lordship the fact and then I'll deal with the law. It will be better. My lord, kindly take his perjury application once. My lord, the perjury application itself, my lord, starts effectively at page 879 in volume 6. My lord, has that? In volume 6, Mr. Banerjee has placed some paragraphs. Now, kindly come to just 2 passages. Please come straight away to paragraph 35 at page 889.
879, 889.
That's right. 889, paragraph 35. Just 2 paragraphs and I'll come to the prayers. On September 3, 2025, the applicant meaning him, my lord, has been able to lay its hand in respect of the said financial statements and our annual returns and our balance sheets filed by said financial creditor with MC and uploaded on the official portal. Please make a note of the years. His main grievance is regarding these 4 years, 1819, 1920, 2120, 2122. Saying apparently these are forged. Now, my lord, kindly straight away come to paragraph 62 at page 897. This is particular the perjury.
Paragraph 62.
Yes, I'm showing these paragraphs only to show that the subject matter of his supplementary and the other I are the same as the perjury, where of course he can't argue that I don't have the right. So it's very absurd of him to argue that in two, with same subject matter, I can file a reply, but in one I can't. Now kindly come to, yes, paragraph 62. Kindly have a look at this. A. Knowingly the said deponent, namely so-and-so, is one of the directors of the said financial creditor, affirm the supplementary by annexing false fabricated MGT 7 and MGT 14. Now, my lord, kindly come to B is 186. Now, kindly come, my lord, just to shorten it, paragraph E. The said directors, namely so-and-so, so-and-so, are the directors who have purposefully given false evidence by signing financial statements, wherein it has been stated. Now, my lord, come to the prayers, my lord. Kindly come to, my lord, page 863. That is the notice of motion. Prayer K was placed, the other prayers were not placed during today's hearing. 863, my lord. Prayers are in two places, my lord. I marked from 863. That's the notice of motion. Excuse me. My lord, prayers A.
863 is which IA?
My lord, that is perjury IA. Perjury. 1519. This is, my lord, the subject matter of this 227 today. This perjury application. Now, my lord, prayers A and B.
1519 is perjury.
That's right. Now, my lord, prayers A and B, nothing to say. These are in the nature of perjury. Whether it's maintainable or not is a different issue. Now, please see prayer C at page 864. An order be passed by this learned adjudicating authority not to rely upon the purported supplementary affidavit and or the documents annexed to the same duly filed by FC before this learned adjudicating authority. In the meantime, at the said supplementary affidavit duly affirmed by the accused persons, namely so-and-so, along with the designated partner, along with the documents annexed to the subject matter of the present application, as also the subject matter of the act of perjury being committed, and as such, no reliance be placed on the same in the meantime. Now, my lord, pausing here for a moment, 379 and 215 does not contemplate an interim order to such effect. Preliminary inquiry, I will go to jail if I've committed forgery. What now? Kindly come to prayer G. An order be passed staying the hearing of the present company petition being so-and-so, and or any application or application pending therein and or thereunder till the instant application is heard and finally disposed of. He's basically asking for a stay. Why? His perjury is pending. Now, my lord, kindly have the two applications, two other pleadings he files on the same day as the perjury. I wanted to show your lordship the perjury because his grievance is regarding one resolution that I've uploaded on section 186 and 4 financial statements. Now, please take, my lord. I'm handing over, it's his own pleading, my lord. I don't want to hand over anything, my lord, additional or my pleading. Now, please give them a copy also. Please have, my lord. This is the supplementary affidavit that they chose to file on the same day as the perjury. Please have a look. Give them a copy, please. Now, my lord, this is, as your lordship will soon find, is affirmed on the same day. Now, kindly come to paragraph 3. Paragraph 2, affidavit is being filed. So, and then paragraph 3. Please see there's a mention of the annual reports for 1819, 1920, 2021. Now, see para 4. That the annual report for FY 1819, 1920, 2021 will demonstrate that applicant has acted in contravention of 186. Now, para 5, same, my lord. Now, para 6, para 7. Now, my lord, kindly, it's repeating. My lord, kindly see, my lord, paragraph 10. From the foregoing facts, it is evident that the person who has affirmed the supplementary filed on July 16 has made averments that are inconsistent. That's the perjury, because the July 16 affidavit gives rise to his perjury because I've included an alleged forged document or forged financial statement there. Now, my lord, kindly see para 11, grounds of fraud. Please see 11.1. 186 is mentioned in the 4th line of 11.1. Then please see the next page, my lord, 11.2. Deliberate filing of manufactured and fabricated documents before this tribunal amounts to an act of perjury. Then 11.4 fabricated documents were introduced into the record through so-and-so perjury under 191, 193. Then, my lord, see what he praised for, my lord. Kindly come to page 7, paragraph 14. No, before that, last sentence of para 13. The actions collectively amount to a fraud on court, attract perjury, and constitute gross abuse of judicial process. Para 14, documents being annexed as A, B, and C, which is he is disclosing, saying that it's fraudulent. He wants to point out inconsistency, be read as part and parcel of CP for fair and proper adjudication. Now, my lord, please take his other IA 1520, which is also filed on the same day. Please take this, please give them a copy. No, supplementary table. Please take, my lord. This is again, they chose to file another application on the same day. Now, kindly come to the very first page. Now, please see the prayers, my lord, on the first page. Please take it from me, the same. I'll just show 1 or 2 paragraphs just to correlate. Prayers are first prayer. Based on these annual reports and financial statements, to call these persons for summoning an inquiry. Prayer B, please see, subpoena, last line of prayer B, to clarify veracity of the statements. He's asking for a clarification. Prayer C, subpoena again to clarify. Prayer D to produce, and prayer F to stay. And my lord, if your lordship makes a note, I'm not taking your lordship through it. I'll stand corrected by my learned friend. In my limited understanding, it's identical. Please come to, my lord, for example, page 12 of that application, internal page 12, paragraph 4. I just want to, for the sake of completeness, point out paragraph 4 refers to the annual reports for 18, 19, 19, 20, 21. And towards the bottom of paragraph 4, it also refers to NGT 14, which is his principal grievance of forgery. Now, kindly come to paragraph 6. He is asking for deeper inquiry. Lord, your lordship has to rise, perhaps.
There is a division bench. I have at 3.
My lord, can we come back today or any other day, my lord? I'll take 10 minutes, my lord. I'm sorry. No, I thought your lordship was rising for a break.
No. I have a division bench at 3.
Why? Any day, my lord, I can come back.
He enjoys in NCLT. He tries to enjoy the same privilege.
When can we have it?
Any day. I'll take, my lord, 10 minutes. I won't exceed.
We haven't.
You take Mr. Banerjee after we.
Half an hour, my lord. Half an hour. He is into facts, so I have to show the facts. Then I did. I only argued on the law points. He's on to facts, so I will show the facts.
Yes,
now,
yes, you show them.
No, he's only showing that there are other prayers.
Correct.
Also which
No, he's showing, my lord, pleadings. He's showing affidavits.
You
So I will show,
won't
my lord.
perjury.
I will show, my lord. I'll show, my lord. I will take half an hour only. Half an hour enough, my lord.
Heard Mr. Banerjee, learned advocate, appearing for the petitioner. Mr. Mitro, learned advocate, appearing for the opposite party, is yet to conclude. Full stop. Director. 23rd.
23rd. No, 23rd, I have some difficulty. Any other day, lordship.
24th or 22nd. I don't have 24th.
24th.
My lord will not denude me of my juniors, my lord.
Have it on 23rd or 24th because
24th then, my lord.
60 করে নাও না
20
আরে ফ্রাইডে খুব ভালো
Friday.
Friday lordship nowadays don't have that bench.
Assigned matters are there.
Oh, my lord, that date there is a chance of a Muharram, my lord.
29.
ছুটি আছে
29th.
29th lordship keeps it because
29th difficult. Why not 24th? What is the problem?
24th he has a difficulty, my lord.
Before that, 22nd কি আছে দিদি?
25 is also all right, my lord. No difficulty at all. 25.
25 তারিখে কোন
পরেশ কোথায় কেউ বলেনি তো, 25 তো ডেটই বলা হয়নি।
25 কর না।
আরে ও নেই, বুঝ না।
30th.
For 29th, Lordship keeps it on Monday, my lord.
Week beginning 29 till 10th.
29th? Lordship is not there.
Yes.
একটা কাজ করি তাহলে
Again?
may I make one prayer? On 24th or 25th, may I conclude? Let Mr. Banerjee
Yes,
and
yes.
Mr. Dasgupta. Oh, very good.
I want to conclude.
Yes, my lord, it won't take too much time from my side. Mr. Banerjee will have to rejoin. Hey, then, Nana, please don't send it to July. It's
আরে থাকছেন না
no, no, that's
29
why I'm saying
থেকে।
before 20. I'm praying for before 20.
তোমার তোর কনভিনিয়েন্সটাই দেখবি, ওর কনভিনিয়েন্স গুলো
না,
দেখবি।
আমি তো বলছি any day.
কত ওই উইকে অনেকগুলো ফিক্সড আছে, ওইভাবে রাখা যাবে না।
আমাদের ওইটা
হাসনা শুনে লাভ আছে। By 24th you will be there. What is the problem?
No, I am not there on 24th, 25th and 6th, they are not there, my lord.
Somebody will be there to assist. Conclude it.
Nobody is there, my lord. I would be 26th, 26th. 26th Lordship keeps it. না না কোনো ছুটি নেই, ফালতু বলে ছুটি করছিস। There is no holiday, my lord. Kindly keeps it on 26th, my lord. আরে কোনো ডিক্লেয়ার হয়নি তো।
That will be difficult.
It is not declared, my lord.
No, because that will be.
তো 25th ও হতে পারে।
No, 29th, your lordship is not there.
Yes, 29th also,
No,
my lord.
lordship is not there.
23rd এ কি আছে?
না 23rd I said I'm not there.
22?
22. Safe is
4 PM করে দিন না।
হ্যাঁ at least ওর শেষ করে দেবে।
22nd, 4 p.m. will be a problem for me, my lord, unfortunately.
22 বলছে, 22 4 PM.
22nd, 4 p.m.
আচ্ছা।
কি আর্জেন্সি কি আছে?
It has to go to July.
Yes, my lord. Kindly keeps it, my lord, so that we can finish it, my lord.
My lord, may I pray for 24th from my end and then they can...
My lord, he will choose his options. I am there on 22nd at 4 o'clock.
Then it will be the same thing.
I leave it to my lord.
Because
I leave it to my lord.
It is not concluded.
22nd was the only day I had some difficulty at 4 p.m. But other than that, any day, whatever your lordship
What about
fixes,
the earlier week? 15th, 16th?
I have no difficulty at all. No difficulty. 15th, 16th, all are fine.
Yes, Mr. Banerjee. 17th করে দিন।
17th, grateful.
2 PM.
I am so grateful. I'm so
Grateful. না ওটা তো আছে, ওটা আছে। আচ্ছা শোনো, শোনো, এই
কেউ নেই এটা ওই ভেতরে কার ওই সাইডে রয়ে গেছে কল করে দিন ফটো যদি কেউ থাকে তাহলে হয়ে যাবে না থাকলে আর কি। যা যা আছে লিখে দিন
For the 96, my lord, I am for the petitioner. আচ্ছা। My lord, I am for the petitioner. Suit for divorce filed by the wife, my lord, in the year 2016. Issue was framed in 2025. Thereafter, my lord, several adjournment dates have been taken by the wife, my lord.
2016 or 2023
Oh, sorry, my lord, 2023. Sorry, my lord.
2023 I'll not fix a time frame. I'll say expeditious disposal according to the business this revisional application C
Sixty. Triple six.
Well, it is a suit for declaration and injunction. We are a defendant in the trial court, my lord, and we are agriculturists. It is a matter of 2022, and my lord, ওনার দেখুন কি 588 না কি আছে, give your numbers, লিখুন it's 501
না আমার 587 আছে
501 কেউ নেই ধরুন এদিকে খেয়াল রাখুন 501 কেউ নেই
493 টা কি I 487. My lord, my lord, apology, my lord. 487, my lord. I was running, my lord, on that. By that time,
487 টা আগে দিয়ে দিন তারপরে
487.
487
টা আছে তারপর
3823. I apologize, my lord, for this person expeditious disposal, my lord, of a suit.
3823
3823, my lord.
yes
Man, expeditious disposal, my lord, of a suit. My lord, the
suit
suit
of
was
2024 I will not fix any time frame.
well, kindly give, as expeditiously as possible, my lord. Only that possible.
This revisional application seeks expeditious disposal of title
Lordship October 2023 and in temporary injunction till date not hard lordship next date fixed in 20 lordship as expeditiously lordship
one application while the partition suit, my lord, application while one application while file while under order on rule 10-2 while in 2017. Since then, my lord, the
declaration injunction, my lord. They have filed obtained an order of identity injunction. I have filed a application 39 rule 4 to which written objection has been filed, my lord. Next date is fixed on 1st of July 2026.
Lordship. Lordship.
500. 502 maybe. No, see 447. 502 maybe. Hmm. 550.
I 15, 550. Calcutta. Sorry, outfunded controller market that is SBO. Yeah, that is normally 22 it is spending money. Only giving the software.
Say 7.2 application has been filed and it is, my lord, delayed for long. So I want to expedite disposal of the bills. 7.2 is not applicable at all for delaying the matter. Application has been filed and neither the applications are heard nor the suit is disposed. All right. Or at least the application on 7 on 7.2. Yes. without granting unnecessary. That will suffice. That will suffice. All right.
502 may be taken. 524, my lord. The suit is pending since 2008, my lord. And there was a direction to frame issues on 2010. 524.
The 50.
520.
502 may be taken by 2014 suit, my lord.
561.
520.
502 is 519. 50. 502. 502. 502 আছে তো 50 501 হয়েছে 5 Great. Beautiful.
And the opposite party filed one cancel suit number 6 of 2025 prior for declaration that the plaintiff has my lord, but from the my lord, from the date of filing come to the order copy, my lord, he is asking for time. My lord, without granting any adjournment, my lord, my prayer is
March 24. 524.
my lord, from the date of filing, SR and AD has been on. My lord, I am suffering.
ঠিক আছে।
Well, from the date of filing,
It is 2008 shoot, my lord. Issue.
My lord, may I mention, madam, my lord, extremely.
একটু দিয়ে দিন না।